Any way you feel, hey, am I right? The sky said goodbye. He was just a hired man, working on the dreams he planned to try. Years go by.
Southside from Mr. Delbert McClin.
Right there? Sure. You want to bring it down? Yeah. Or do you want to take it loose? Take it loose.
Whatever's easiest.
Thank you, Buzz.
Hello, everybody out there.
Hello.
I'm talking to the people in the hallway. Come in, please. Okay, for those of you who don't know, I'm Jennifer Ford. I'm the one that invited you all here. I wanted to talk to you just for a couple of moments about the genesis of this event, how we all sort of came to be here tonight. It started, I'm a Nova Law student, and I was taking a class in post-conviction relief taught by Carlos. There he is, Carlos Gonzalez. And the entire course was just to read a 20-year-old trial transcript and write a motion. That's it. And I took the transcript home one weekend, and I spent 3 days reading it and rereading it and rereading it because I couldn't understand how somebody got convicted with like no evidence against them. And it was shocking to me, and I thought, this is disgusting. I mean, there was no evidence, just one random guy that said something, that was it. And I thought, this has got to be an anomaly. This has got to be something that just rarely happens. So I did a little research, and disgustingly, it's not rare. It happened a lot in the 80s and 90s, and these people are just housed in prisons for decades for doing absolutely nothing. So I was kind of sickened that weekend, and I couldn't really sleep. And I called Carlos, I think it was Monday or Tuesday, and I said, this is disgusting. Like, I want to do something. Can we do something? What could we do? And so we came up with an idea to have some sort of seminar or information symposium, whatever you want to call it. And this is how we ended up here this evening. I didn't know exactly what we were going to do. We kicked around a few different ideas, and we decided we wanted to have a guest speaker. So I did a little more research, and I found William's story, Mr. Dillon. And I was so touched by his story, and I really wanted him to come here. So I just called him. Actually, I started to look for him first. I couldn't find him. I thought he was in North Carolina, and he wasn't. So I kind of hunted him down a little bit. I'm not going to tell you how I found him, but I found him. And he was in California, and I called him, and the phone rang. He answered like on the first ring, and he said hello, and I kind of was a little shocked because I didn't really expect to get him. And he answered the phone, and I told him, really quickly what I was doing because I thought he might hang up on me thinking I was like a telemarketer or something. And he listened to me for a moment, and he says, how did you get this number? So, but he didn't hang up, thank you for that. And almost immediately, I would say within 4 minutes of talking to me, he agreed to fly thousands of miles to come here. So it was just unbelievable to me. I couldn't believe he did it. I couldn't believe he agreed, and he immediately gave me his cell phone number. Just a complete random stranger calls you, you give him your cell phone number. I mean, he's just a sweet, humble guy. And thank you so much for coming tonight, Mr. Dillon. I also want to thank a couple of people before I turn the floor over. I want to thank Nova for letting us have this venue. I want to thank the Neon Madness Band. Let's come to entertain us, and we appreciate that very much. Let's see who else I want to thank. I want to thank Genevieve for feeding us tonight. Genevieve, Jablo, and Batista. But the marketing manager at his firm, Miss Liz Lavachi, right here. Today I will be standing here talking to empty seats because I had no idea how to do marketing or any of that. So all the marketing stuff you see, Liz did that. Thank you, Liz. I also want to thank Ed Fitzpatrick. Where's Ed? Ed is the man. He's the manager of this theater, and he agreed to stay after work, after he's already worked all day, to help us with this event. So thank you so much, Ed. Also, Bonaventure Spa and Resort, and they, I guess, upgraded our guests, and they have some beautiful suite, apparently, and food and beverage, I guess, comp to them. So thank you for Bonaventure. Another person, Raquel Guerin. She is the head of the Evening Walk Society Student Association over at Nova. She can't be here because she's literally, as we speak, taking a final. It started at 5:30. Speaking of which, I just took a final the other day, Richard Grosso. Thank you for that. That was fun. That was a lot of fun. Okay, so now I'm going to turn the floor over to Carlos Gonzalez.
There's really not much more that I can add to what Jennifer said, other than to say that really the credit for this event goes entirely to her. although she used the pronoun we repeatedly, it really came down to her efforts and the efforts of the Job Law firm, which has really been outstanding in their support of this event, and ladies, and all of the work that she has done. So that really is the reality, the truth of the matter. This event really is designed to highlight, I think, Mr. Dillon's story and the important thoughts that he has to share with you, because I think that they are important. I think they signify a real problem in our system, and that's really what I'd like to just highlight very briefly. The class that we teach here at NOVA, called Post-Conviction DNA Testing, is a class that's really designed to open students' eyes to the problem, a fundamental problem, a systemic problem with the criminal justice system. Mr. Dillon's story is a unique story. It is a difficult story to listen to, and I would tell you that it's not the sad part, or one of the many sad parts as a lawyer looking at Mr. Dillon's story, is that this happens and it continues to happen. And there has to be a collective effort within the community. When I say the community, I mean the legal community. To look at how we prosecute cases, how we investigate cases, both from a defense side and from the state attorney's side. That's absolutely important. I always tell my students that they should be friends with one another. They should always make sure that they're friendly, because the people that they sit with in class will someday be the judges that they appear before, the prosecutors that they face, the defense attorneys that they have to deal with, and more importantly, the politicians who make the laws that we have to live by in this state and in this country. And there has to be a collective effort to really look at how we prosecute cases, how we investigate cases, the use of scientific evidence in prosecutions, the incredible use of junk science in prosecutions that really has led to an incredible degree of injustice in our system. And so I think that events like this really highlight really why I practice law and why I went to law school in the first place. And hopefully when you listen to a student like Jennifer, who, if I may, speak out of school here, told me that she has no interest in criminal law, never wanted to practice criminal law, sort of fell into my class and didn't even like me as her professor when we started, who came around after reading a trial transcript and realizing that a great injustice occurred to the individual that we discussed in our class, and to Mr. Dillon and many others, over 300 individuals who have been exonerated to date across the United States. There are some very important lessons that we have to learn and that we have to hopefully implement in the form of good public policy. So I thank you all once again for coming. I know that we're in the middle of finals. So you're either taking exams or grading exams, and so it is a time commitment to be here today, but it's an important, worthwhile cause, and so I do thank all of you for being here today. Mr. Dillon, the floor is yours.
Thank you very much. Can everybody hear me?
Yeah.
Good. Before we start this, I hope I'm not doing this out of turn, but I would like to introduce somebody else that would lead me into this. His name is Mike Perillo. He's my public defender that saved me from this great thing, and he's more inclined to tell you what you're really trying to hear here, because all I have is a sad story of a young kid that got taken in the wrong path. But I'm going to let Mike open the door up and let him talk to you first about the journey that he did for me, and then I'll come in and tell you my story, okay?
Great.
Bet you didn't know that was coming.
Not cool.
Yeah.
Bill's story is more than a sad story. I would never classify that as a sad story. It's a story of redemption and faith and just inner strength. I met Bill. Bill had filed a pro se motion for DNA testing. So if we're going to get in the legal area about it, it starts off by someone filing a motion for DNA testing. And the motion pretty much says that if you grant the DNA testing, there's items that are available, and the DNA testing will exonerate the appellant or the movement in this particular case. So with Bill's case, it was, he comes in with a pro se motion. I get called in the court. because he wants counsel appointed. And the judge says, okay, Mike, here you go. And I met Bill for, I don't know, 10 or 15 minutes in the holding cell that's right next to the courtroom. And I've said this many times before when I've spoken, so I'm not mentioning this for the first time, but I've heard many, many people say, you know, I didn't do it. And a lot of times they're right, sometimes they're not. But when reading Bill's motion real quick and just talking to him within the first 5 minutes, I knew he was innocent. It was just a genuineness behind his words, his face. I could look him in the eye, and I just knew, for lack of a better term, this guy had been screwed many years prior. So the decision was to whether or not either just request a continuance just to have a review of the motion so I could file my own motion, or adopt Bill's motion. So we just decided to, why rush? Bill only waited about a quarter of a century for this, so why rush a few more weeks, and let's make sure we got everything that we need in this motion. At the same time, we got the Innocence Project of Florida. They're located in Tallahassee into the case. The Innocence Project, Seth Miller and Melissa Montel were awesome to work with. So pretty much it started off, we had to dig up the old case. And talking about a case from in the early 80s, 1980, 1981, and it's not that easy finding old cases, especially in Brevard County, which is where this case originated from. So very quickly found out some things were missing from Bill's file. But at the same time, knew that there were other exonerees from Brevard County, Wilton Dedge and Juan Ramos. And so I got those two files and started looking through those. And we started to see just a pattern of misconduct between the three cases. And you're talking about three cases from the same county that are prosecuted from the same state attorney's office and the same sheriff's department. Back then, the sheriff's department worked all the homicides and rapes and serious crimes. So the pattern of conduct was pretty, just smacks you across the face if you really look through it. But we started looking through that, but more importantly, we got to be focused on Bill's case. And there were many items of evidence that, looking at it, we figured we should have tested for DNA testing. And it took a while to find those items. There were some items that were never found, which was pretty upsetting to me, because on a homicide case you shouldn't destroy anything, let alone a sheet of paper, let alone evidence that's presented in a first-degree murder case. So I remember the day because we had the clerk, one of the clerks from the courthouse had to bring up the boxes of evidence that they had left over from the trial. And there were numerous boxes, and going through box after box, we're pretty much not finding these items that we want tested. We found a couple, but the biggest item we wanted was a yellow t-shirt. This was a t-shirt that at Bill's trial, the prosecutor is holding up, telling the jurors, this is the t-shirt. Blood on this t-shirt is Mr. Dvorak's blood, which is the victim in that homicide. And we know who wore the shirt. Bill wore the shirt. So they're saying this shirt not only was worn by the killer, has the victim's blood on it, and also has an odor on it that a dog expert had his dog sent back to Bill's odor. That basically, they collect this t-shirt, and a couple of weeks later, when they're talking to Bill, the dog walks in, smells a crunched up piece of paper, and says, aha, there's a hit. The odor on this piece of paper is the same odor on this t-shirt that was found 2 weeks prior from this bystander. Use that term loosely too, but he said he picked up this hitchhiker carrying this yellow t-shirt. So that was, in essence, the state's case against Bill, and you kind of got to work backwards because you got to look at, okay, what did the state use to convict Bill? That's the same evidence we want tested, or some evidence that wasn't tested. And there was a lot of stuff that wasn't tested. Now, remember, this is 1981. There's no DNA testing. The best they could do is say, it's a B blood or A type. That's the best they can do. So we filed eventually our final motion for DNA testing. And within the motion, we basically got to also argue that the results will be that of a nature where if a jury were to hear those DNA results, they would either acquit or return on some lesser count. Now, obviously, our position was that they would just acquit. There would be no lesser second-degree murder or manslaughter or anything else. This would be a straight acquittal. That was the easy part, arguing that part. What was more difficult was we were up against Wayne Holmes, who is now retired, but he was pretty much second in charge of the state attorney's office in Brevard County. And he was in charge of these post-conviction cases. And you could tell him anything, you could show him all the evidence in the world, show him that they had the wrong guy, and he doesn't care. Conviction is a conviction, it's a win. We're not going to let go of a win, no matter if it was 2 years ago, 20 years ago, 25 years ago. We're not going to let go of it. We're not going to admit any error, even though Wayne had nothing to do with Bill's initial case. So we had to put forward evidence in front of a judge that to show, okay, there is evidence, and this is what the evidence, the type of DNA evidence you get from it. I don't think we had many witnesses that were very cooperative. I mean, you're talking about witnesses from the state attorney's office and from the sheriff's department, so no one's going to sit there and claim error. But anyway, the judge ultimately held that he granted the motion for DNA testing, and he then asked myself and Wayne Holmes from the state attorney's office to draft up an order. And the judge in his ruling says this is what I want in the order. Certain items have been located. This is where the items are. This is the kind of testing you want done on the items, and this is the protocol that the lab tells you that they need done to ensure chain of custody and no contamination. And we actually were fortunate enough that the Innocence Project agreed to pay for the DNA testing at a private lab. We didn't want Florida Department of Law Enforcement lab to do the testing. We didn't want a lab that the state, there was a couple of private labs at the time that the state would send evidence to. We didn't want pretty much any lab associated with the state. So we sent it off to a lab that at the time was called Orchid Cellmark in Texas. And again, the Innocence Project was grateful enough to pick up the tab. My office pretty much has said, any experts you need, just get them. You don't even need to go through the proper protocol of the cost approval that we do in our office. Said you want someone, go get them. So we thought that then the easy part would just be putting this order together, and the state fought us on that. And I think it took almost 6 months or so to get this order agreed upon. We had to have a status hearing with the judge. I had ordered the transcripts from the hearing, and pretty much word for word in my order wrote down what the judge said needed to be in the order. And the state disagreed each time. That's not what the judge said. Well, here's the transcript, black and white, this is what he said. But anyway, we thankfully got the order ultimately signed. And so all the evidence that we found, specifically the yellow T-shirt, we sent off to the lab. And we were waiting for the results. Now, in the meantime, we had several hearings, and the state would shift their argument from hearing to hearing, which really upset me and just pissed me off, let's be honest. We're in a courtroom, same office where 25 years prior they're talking about this T-shirt, it proves that Bill Dillon did it. And we're at one hearing where Wayne Holmes says, well, this T-shirt's irrelevant. Judge, you shouldn't grant DNA testing on this shirt. It's irrelevant. The victim's blood's not even on the shirt. We were wrong at trial when we said it was the victim's blood. So You know, I'd been practicing probably about 3 years, 4 years at this point. So I've heard some BS from a prosecutor before. And I don't mean to disparage anyone that knows prosecutors, wants to be a prosecutor, has been a prosecutor. I know a lot of them. I'm friends with them. There's some I trust, and there's some I will not trust. There's some that I will trust more outside of the courtroom than I would inside the courtroom. But it was just very, just disconcerting that, you know, someone who took the same oath as I did is sitting in this courtroom. Again, a case has nothing to do with it. He didn't try the case. He wasn't affiliated with the case whatsoever for him to stand up and start doing that. And then another time would be, well, you know, if you test a shirt, it doesn't matter, it's still irrelevant. And it's like, you know, how can you go from one prosecutor, you know, sticking the shirt in front of the jurors' faces, saying that's the victim's blood and this shirt was worn by that guy, and now years later saying, don't forget about the shirt, judge, don't even get this tested. The judge, you know, thankfully saw through that. So then we waited for the DNA, you know, testing to get done, and the testing got done, and we're on a conference call, and they say, you know, Bill is 110% excluded. They found the blood on the shirt matched that of the deceased, so we knew the shirt was tied to the crime scene. Because now in the back of my mind, I'm worried that, you know, the prosecutor's arguing this is irrelevant. It's not even the victim's blood. I'm like, well, what, you know, where does this T-shirt come from then? So that was the first good news, was the deceased blood was on the shirt. And then he said there's only one other profile on the shirt. It's inside the shirt. It's by the inside collar of the T-shirt and the armpit area. And I'm thinking there, all right, you know, common sense. You know, someone's beating somebody up, because this was a heinous beating of the death of Mr. Dvorak. So common sense would tell you, and it's done in August, so, you know, Florida weather in August, it's muggy, humid, your skin is going to be moving around in the shirt, you're going to be sweating. So he said one profile was found on the inside of the shirt. It's not Dvorak, the deceased, and it's, I'm waiting, okay, well, tell me it's not Dylan's either, and we're good to go. And he finally said it's not your client's either. And I'm like, fantastic. They had a full profile they could work with to, you know, potentially run through CODIS, which is you know, a database of people who've been through the criminal justice system and been to prison, that their DNA is on file. But he said, you know, it's not your client. So we got word to Bill. And again, you know, silly me thinking, okay, this is going to get easier now, and it only got harder. You know, the point I'm trying to make is these cases don't happen because a prosecutor just made a silly mistake. And maybe there are, but at least the cases I've seen involve law enforcement officers that know what they're presenting to a jury is fabricated evidence. They know it's not true. There's no gray area. They know what's true and what's not. In Bill's case, there was a witness who was threatened with 25 years of prison as an accessory if you don't say that Bill said certain things to you or you saw him do certain things. Yet another, and what's famous in these cases is virtually every one of these cases has that witness that then recants afterwards. That's what we had in this case. And all these cases have a jailhouse informant, and we had that in this case. We had a guy who was facing sexual battery count, and he was facing over 30 years of prison. And he says, yeah, you know, Bill confessed to me in a jail cell. And lo and behold, after he takes the stand in his trial, sexual battery count is dismissed, and the guy, you know, goes home. And meanwhile, Bill has to suffer for the next 27 years. And these cases also have some junk science, as Carlos was talking about. In our case, it was dog scent evidence. There was a guy, John Preston, who had been hired by the state attorney's office in Brevard County on more than one case. This wasn't the only case, and this is that link, that pattern I was talking about earlier. He was also involved in Juan Ramos' case and Wilton Dedge's case. And pretty much he had this magical dog. And he actually flew around the country testifying. Many agencies hired him. He testified in Arizona, in Oklahoma, all around the country with this magical dog. And he says, my dog can pick up scents that are a day old, a week old, 6 months old. And my dog's never wrong. And that's what they did in this case. They had John Preston testify that his magical dog can pick up a scent off of this T-shirt and say in the same scent on this crumbled piece of paper that they had Bill crumble up when he was talking to the police, it matched. One of the experts I was able to hire in our case was from South Carolina, and he's a guy that trains FBI dog handlers. He's like the guy that the FBI goes to, and he's also worked with the CIA. He trains the dog handlers, and he also has people that he works with to train the dogs, the actual dogs. And we got videos of John Preston from many cases before Bill's, and he looked at the video and he says that the guy's not tracking, the dog's not tracking. He's leading the dog, in a track. The dog leads the handler. This is the handler's leading the dog. He says it's no different than when you take your own dog for a walk, and this is what this dog is doing. And he was appalled by it. He was appalled that judges allowed this guy to testify, let alone that this was a crucial piece of evidence, putting Bill in prison for so long. So he said, you got me. Whenever you got the hearing, let me know. I'm going to be there. If I got something scheduled, I'm going to cancel it because he's a legitimate person who's trained, and he trains in this field. And he says, the guy made a mockery of this. And he says, first of all, he's like, you don't base a case just on a dog scent. And he says, common sense tells you a person, more than one person, could be in the same area. And you can't really differentiate between what the dog is smelling. Is it, connecting to the actual perpetrator or some other innocent bystander that was there before or after the person? So he says, if anything, it helps in investigation. It shouldn't be the end-all, be-all of the investigation. And that's what it was in this case. And they're putting on their expert in front of the jury, and he's talking about his dog is the magical dog and it's never wrong. And the jurors ate it up. But what we found was all of his prior cases were coming back. There was a federal judge in Arizona that wrote an opinion calling him a charlatan. There was a judge in our county who was a circuit judge at the time and then went up to the appellate court in Daytona. But at the time he was a circuit judge, he had Preston on a case, and the defense lawyer filed a motion in limine to prevent him from testifying. So he set up a 2-day track, basically. He said, all right, well, I'm going to set up an experiment. I'm going to go see someone, and the defense lawyer had hired another expert that involves dog tracking. And along with the judge, they set up a track, pretty much a test, 2 days to see was this guy legitimate or not. Day 1, he failed miserably. Day 2, he didn't show up. Flew out of Brevard County. The state finally dropped their case in that particular case. But these were instances where the judges in Bill's case, on a motion for new trial, could have granted him a new trial, and they refused. So one of the witnesses came, recanted her testimony. The judge still didn't give him a new trial. So you fast forward 25 years later or so, and that's how critical the DNA evidence was. Because now the DNA evidence, at least in the court's mind, is much more than just some fabricated evidence. It's much more than some lying witness or witnesses. Now you got some solid DNA evidence and scientific evidence that you can attack it all you want, but the peer reviews are always going to come back, and every expert's going to say, as long as it's done properly, it's extremely reliable and accurate. So we fought for about almost 2 years since Bill came in with that pro se motion for DNA testing. until the state finally threw in the towel. And on the eve of a 2-day-long motion for new trial we were going to have, they approached me and said, we'll stipulate to the new trial, but they wanted to do it under the rug. They just wanted to brush it under the rug. It was the day I was in court, and Wayne approached and he said, we'll stipulate, but let's just tell the judge now. And I said, no, you're not going to get away with it that easy. First, Bill's not even here. He's at the jail. I got to get him over here. And I said, Bill may not stipulate. Bill may want this hearing. I wanted the hearing. I wanted the hearing because we had all this evidence ready to go just to show how corrupt of an investigation it was and how awful of a cover-up it was and how bad the cover-up was continuing to go on. But obviously it's Bill's interests at stake there, and Bill came over and said, hey, they're going to stipulate to a new trial. So that was done. And then we got a trial date set, and then probably a couple of weeks after our new trial was set, or the motion for new trial was granted, they faxed me a notice of nolle prosequi, which was a dismissal. They didn't call, they didn't email, they just faxed it. I just happened to have a secretary that was walking around, went by the fax machine, saw it, and knew, the whole office knew, Bill's case. And she looked at it and said, holy crap. And she walks into my office with it, and I just sat there. I was like, you gotta be kidding me. They couldn't even call me or even email me. This could have sat to the next day, and Bill, still just, waiting for news. So, obviously the first phone call I made was to Bill, and he went and got his GPS monitor cut off that same day. Because in the interim, what happened was when he stipulated to a new trial, I asked for a bond hearing, and we had a hearing, and the judge granted, Bill a bond hearing, a reasonable bond. The Innocence Project also helped out with the bond. So Bill at least was out, waiting for his new trial, with some conditions and a GPS monitor. But it was his first sort of taste of freedom at that point. But the legal technicalities they're not that difficult when you read the law. It's what the state makes it into. The law is very simple in terms of you just got to show that the result will be different. And if you've got this evidence, the judge should grant it. What the state likes to do is really muddy it up. They like to say, well, it doesn't matter that those witnesses recanted. Their first testimony should be looked at as true. The junk science, okay, maybe it's junk science, but when you add it with these people that told the truth the first time, they're not telling the truth when they recant. They only tell the truth when they're trying to convict someone. But that's fine, and this whole DNA business, that's just the defense trying to muddy up the water. So that's the biggest thing you would have to worry about. And then it's the actual testing, and I guess a client that's actually telling you the truth. But the thing is you're going to encounter a lot of people that say I didn't do it. That's just the nature of the beast. But I think when you know. It's one of those things. You know it when you see it. I knew when I saw it without even looking at the evidence, just talking to Bill. And then when you really open up, the file and really go through it, again, it smacks you right in the face of how bad of a case it was, and bad of an investigation it was. But Bill's been a very strong person throughout the whole process. I remember, seeing him in court. I'm up there, acting all obnoxious and objecting and arguing and getting stressed out, and I keep looking at him at the defense table, and he was all calm the whole time. I'm like, why is he so calm? But, I think it was calm because deep down he knew. He knew, listen, I didn't do this. I've known the whole time. I've just been wanting someone to listen. Now I'm finally somewhere where someone can listen. I got Mike who's listening, my family's listening, the people from the Innocence Project are listening, and now this judge looks like he's finally listening to me. And he looked real calm and he was real patient. You know, I'm happy to say that ever since November 18th of 2008 now, and Bill's been officially a free man and exonerated man. I've known him since that time, and we've kept in touch. And again, as the first thing I said here when I got up here, I disagree when Bill says it's a sad story, because yeah, a lot of it is sad, but I don't think it's a sad story. I think it's a very happy story. It's a story of strength, because he's probably the most strongest person I've ever met inside, just because for what he went through, 27 years, I'm man enough to say I couldn't go through that. And we sit here, you know, patiently waiting for one day to say I was right and everyone else was wrong. So I think he's extremely strong for that. And you know, we were very fortunate to be invited to his parents' 50th wedding anniversary a couple years ago. And I said this in an interview yesterday. We had 48 hours of interviewing a lot of people involved in Bill's case. And they're looking at another potential exoneree from Brevard County. Could be a fourth person. So, you know, they asked me, you know, well, tell us, you know, something about that's not from the legal sense of it, you know, how it affected Bill and so forth. I said, well, you know, I'm not sure. You know, I know what Bill went through, and that's not my place to talk about, because he's the one who went through, you know, the brutal horror that people go through when they're in prison, regardless if they're, you know, innocent or guilty. I mean, it's no picnic being in there. But I say, you know, I was at his parents' 50th wedding anniversary, and you start seeing all these pictures. And you see pictures when, you know, everyone's a kid, and the siblings are all kids, and Bill's a kid. And then there's this huge gap. And that's when, you know, Bill's in prison. And I said, you know, Bill was very strong getting through it, but, you know, you got to think about a family that didn't have their son, didn't have their brother, didn't have their uncle. For, you know, some of them were, you know, pretty young. Their whole life they didn't get to have their uncle. So I said that's the real injustice there, because you meet a guy like Bill and, you know, like it didn't faze him at all. I think that's how strong he is. And I know deep down there's hurt, and there's pain and anger, and rightfully so. But that's just the character he's got, that he's not gonna, he goes out there and I've seen him pick up a guitar and sing, and I've seen him speak, and it's not a sad story at all. What's sad is obviously the lost time with his family, but I will always disagree with you, Bill. It's not a sad story. But anyway, on the legal front, if, you know, the professors or any other attorneys ever need any input, you know, feel free to always contact me, but always remember that you got someone out there. When they say they're innocent, there are those that are innocent, and I know for a fact, all I do is death penalty work now, and I know we've executed innocent people, and there are innocent people on death row, so it's a very noble work to pick up those conviction cases, and I would say just be a gigantic pain in the ass until you get what you want. And Bill's a big example of what I wanted and what you get when you're that big of a pain in the ass. So,